I'm Bob Guntharp. I'm an attorney with the Ritchie Law Firm. I have over 30 years of experience practicing law. I want to talk to you today about workers' compensation. Workers' compensation is a complex and rule-driven area of the law. It's covered in over 900 pages in this book. What you know or what you don't know can hurt you. It can make the difference in whether you receive benefits or whether you're denied benefits. For over 45 years, the Ritchie Law Firm has been helping injured workers with their workers' compensation claims. We'd be happy to help you. A consultation is free, and we only get paid if we win. So let's start at the beginning. Let's start where somebody has had an accident. There are a variety of rules that apply in that context, and how you explain things and how you understand the law in that regard can make just all the difference in the world. So the first thing we talk about is something called an injury by accident. Now, this isn't just the kind of ordinary meaning of that phrase. It has very specific, identifiable components. So the first is you have to have a specific event. You have to be able to identify a particular accident where you were hurt, and in essence, you sort of say, ow, I've had an injury. You have to have a structural change in your body of some type. Now, that is a very kind of subject to argument kind of area. So if you don't have a broken bone, that doesn't mean you don't have a case. But that's kind of a term of art. So you have to be careful with that. You have to be able to establish that the structural change was the cause of the physical complaint that you are experiencing. And that's really a medical piece of evidence that needs to be supplied in the presentation of your case. Cumulative injuries. These are injuries that occur where you've just repetitively doing something. They are not covered under workers' comp. There are two exceptions, and that has to do with carpal tunnel and hearing loss. But there can be more difficult levels of proof that apply to establishing those things. So let's put a little meat on the bones and try to put this in more common terms that are perhaps more understandable. If we have two guys, let's call them Bill and the other guy I'm going to call Poor Joe. They're unloading a truck. And so Bill is lifting boxes and carrying them onto the loading dock. And so is Joe. Bill, 15, 20 minutes into this job, bends down, picks up a box, and he feels a sharp pain in his low back, and he feels pain radiating down a leg. And he stops dead in his tracks, and he hobbles out of the truck, and he goes to his supervisor, and he says, hey, I picked up this box, and I've got this really bad pain in my back. I can hardly walk. The supervisor says, well, you got to go to the doctor, and maybe they drive him there, and they take him there, and he has they send him to the ER, and he has a MRI, and it turns out he has a herniated disc, and Bill has to have lumbar surgery, and he has to go through a lengthy period of recuperation and physical therapy before he gets back to the job. Well, he's going to be covered under workers' comp because he had a very specific event that he reported immediately to his supervisor. And I'll get back to this reporting in a moment. His medical bills will all be paid for. And on the 8th day that he's out of work, he will qualify to start receiving a check, 2/3 of his average weekly wage, as long as he is unable to work. Now, let's talk about Poor Joe. Remember, these guys are working side by side. Well, Poor Joe, he finishes that day out. He notices he's maybe a little bit sore and whatnot, but he doesn't really necessarily feel that he had a specific event that was of enough significance that he would stop and go and tell his supervisor. Well, poor Joe goes home that evening. He goes to bed. The next morning, he can't even get up. He's in so much pain. He goes to the emergency room. They do an MRI, and lo and behold, poor Joe also has a herniated disc. Poor Joe also needs surgery, physical therapy, and he is out of work for an extended period of time. Because he did not explain that he had a specific event, he is out of luck. He will not receive any workers' compensation benefits. Now, one thing that's important to understand is this doesn't have to be as severe as the example I'd given with Bill, where he stops dead in his tracks. There are lots of people, sort of in Joe's situation, who complete the day out. They try to shake it off. But there may have been one moment in time when they felt a particular strain, or something happened that was a little bit out of the ordinary, and they took notice of that. That can be enough to qualify you to have had what's called an injury by accident. If you do not have an injury by accident and you do not explain it in that fashion, you will not qualify for workers' compensation benefits. Now, I also want to add an additional caution here. It's don't assume that you don't qualify because you may not have exactly explained it right, because sometimes we can fix that when you have a deposition taken, or there's something called answers to interrogatories completed. And if we have to go to a hearing, sometimes we can fix that. But you really should consult with an attorney in that situation. Anytime you have a workers' comp injury, frankly, of any significance, you should consult with an attorney. There's another component to this process. It's called arising out of employment. So what does that mean? Well, it means that if you're on the job and you have an accident, it doesn't necessarily mean that you're covered. And even if it is sort of a sudden event, like I described before, it still has to arise out of employment. Now, what does that mean? It means, let me give you an example. If you're walking downstairs at work and you just stumble and fall and you break your leg, that does not necessarily arise out of employment, because if you were at home and you were going down the stairs and you stumbled and fell and broke your leg, the same outcome would have occurred. You would have had a broken leg. It has to be tied in some way to employment. It doesn't have to be an enormous connection to employment, but you have to be associated with employment at the time. So, for example, if you're carrying boxes in your hand as you're going down those stairs, and maybe whatever is in that box shifts a little bit, and that throws you a little off balance, and that causes you to fall down the stairs and break your leg, that arises out of employment because you have a box in your hand that is associated with your work, your employment. It doesn't have to be a box. It can be, other things. There could be some other event. It just has to be tied to employment to arise out of employment. So, you got to have an injury by accident. It has to arise out of employment. There's an additional element to all of this. It has to happen in the course of employment. And again, these are kinds of terms of art. So in the course of employment, what does this mean? This means you have to be carrying on some employment activity while you're on the job in order to qualify. If you're driving a truck, let's say you're a delivery guy, and it's your wife's it's your anniversary, and you haven't bought your wife flowers or a gift or a card, and you think, hey, I better take care of this. I forgot about it. And so you run into the mall and you go shopping for an anniversary gift, and you trip as you are hustling in there, or as you're coming out or wherever, uh, that is kind of a personal errand that you went on. And even though you are technically on the clock and technically at work, if you have an injury in under those circumstances, you're not going to qualify for benefits. Now, again, these are things that sometimes are subject to interpretation and argument. So there are certain things, for example, let's say that, certainly stopping for lunch someplace. You're going to be covered if you're injured and you stop for lunch and you're going into a fast food restaurant or something and you trip and you fall. That is incidental to your employment because you're entitled to have lunch and you're out on the road and so forth. It's got to, the accident has to arise out of the course of employment. Another example where things do not arise out of the course of employment is where, there's what they call horseplay. Let's say you're fooling around with some your fellow employees and you're kind of horsing around and somebody is injured. In the course of that type of activity, it didn't arise out of the course of employment. It's called horseplay, and you are out of luck. The next thing that has to happen is you have to give notice when you have an injury. If you have an injury by accident, it is arising out of employment, and it is in the course of employment, you must also give notice. Now, you have to give notice. You're supposed to give notice immediately or as soon as is practicable, because sometimes, I have a more significant injury and may not be able to give notice right away, or within 30 days. If you don't do that, it doesn't mean that you're out of luck, but it makes it tougher because you have to explain that you have a reasonable reason for not having given, more timely notice. It doesn't in fact affect your entire claim either necessarily, but it can affect benefits going backwards from the time you ultimately did give notice to the time of the accident. So you can lose out there. But that is, again, one of those areas that you have to be careful about, and don't assume if you have not given notice that you're not going to have a claim, because I've overcome that sort of situation many times in the past, as I have with these other potential problems that exist in cases. So I'd be happy to talk to you. I'm sure any of the attorneys in the firm would be happy to talk to you as well. There is no charge for a consultation, and we only get paid if we win. So it's a win-win, and I encourage you to give us a call if you've had an injury on the job. Hope to hear from you soon. Take care. Bye.